Hello, this is Matt on the Moon Lambo channel. The SEC admits that XRP is not, and never has been, a prohibited holding, but they also argue that it doesn't matter, and I'll explain why. And they also admit that SEC employees were barred from buying XRP, despite the fact that XRP is not, and never has been, on their prohibited holdings list. A lot to break down here, but I do want to be clear at the outset that I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos, but it's just as a hobby purely for fun. That's all that's going on here. And so yesterday, there was a new legal filing from the SEC to Judge Sarah Netburn. And attorney James Filan, who is a member of the XRP community, shared this document on Twitter and wrote the following. SEC vs. Ripple. The SEC has filed its opposition to the Ripple defendants' motion to compel the SEC to produce documents showing whether SEC employees were permitted to trade XRP and other digital assets. 6 pages in 2 consecutive tweets right now. And so you may recall in a recent video I covered a document from Ripple that was filed in the court in which they're basically insisting that the SEC must share information about whether SEC employees did or did not purchase Bitcoin, Ether, and XRP. For obvious reasons, right? And if it's not clear, don't worry. I'm going to spell it out in this latest Moon Lambo hot jam. But so that's what happened. And then this filing that I'm covering in this video is the SEC's response to Ripple saying, hey, give us the information. We want the information about whether or not your employees were buying XRP, among other things. But in a nutshell, that's it's one of basically the most important part, frankly. And SEC just ain't having it. But I have to tell you, like, I printed up to hear this. These are some dead trees in my hands. I printed up this 6-page document, and I highlighted the parts that are most relevant so that I'd remember to share them with you in this video. And I have to tell you that their arguments, I just do not find them compelling. And mind you, like I said, I don't have a legal background since this is coming from a layperson. So whether or not what the SEC has laid out in here is a good legal argument, as in it could help them to, perhaps win the case, so on and so forth, that's a different idea than whether or not this makes logical sense. Those actually are 2 different things, unfortunately. But so just as somebody who has more than half a brain that has read through this, I can see through a bunch of the crap that they're arguing here. So again, I don't know if it's actually going to help them or not, but I'm going to spell out exactly where I think they're just going off the rails here. And so there's a bunch of interesting stuff. I think you'll find this fascinating here. And so let's go ahead and jump on into the first page here. Dear Judge Netburn, the SEC respectfully requests that the court deny defendants' motion to compel the production of confidential details of trading by individual SEC employees and their family members whose personal financial affairs are not at issue in this case. The sensitive data is collected by the SEC's Office of the Ethics Counsel for purposes of ensuring SEC employees' compliance with ethical rules intended to prevent conflicts of interest, not to determine whether any particular transaction complies with the securities laws. And so, look, Ripple never said that it was the SEC Ethics Council that determines compliance with securities law. If anything, that sounds like a straw man argument. But it was kind of funny. You know how this struck me when I first read that? It just made me think, so it's basically the SEC saying, okay, so not only is it the case that individual employees there that share their personal opinions, none of those personal opinions constitute an official SEC position. And not only that, here's another part of the actual SEC, which also, in addition to the individuals, this part of the SEC, in addition to that, also it has nothing to do with indicating whether or not something is a security. It's like, what the hell part of the SEC actually determines this? Like, it just sounds freaking absurd here. But anyway, the piece continues. While defendants argue that ethics counsels pre-clearance decisions as to any transaction in Bitcoin, Ether, or XRP, as well as SEC employees' trading activity generally, may prove that the SEC determined that those digital assets were not securities, the Ethics Counsel's statement makes clear that defendants cannot make any such argument no matter the content of the ethics trading data defendants seek. And so, look, the broader point remains that despite them citing this, the broader point remains, if it's been clear since 2013, as the SEC argues, that XRP is a security, then why would any SEC employee buy it? Because again, remember, the SEC is claiming that XRP has always been an unregistered security of Ripple, the company. And so if any SEC employee bought XRP, that is strong proof that there was no existing determination that XRP was a security. At the bare minimum, there's extreme market confusion. At the bare minimum here. And then the SEC asset here proceeds and writes, defendant's request falls well below the low bar of relevance the court considered when it ordered the SEC to produce Ethics Counsel's guidance on digital assets and is an unjustified intrusion into the private financial affairs of SEC employees, even on an aggregate basis. Now, that's a key term. So for those of you that watched my video where I was talking about, where I was covering Ripple's position on this topic, they actually, it was very clear. Like, they made the point, they're like, look, even if you're not sending over personal information of the individual SEC employees, because I think Ripple knew that probably wasn't going to happen, they said even on an aggregate basis, just get us the data. We don't need the personal information. And so check this out. Like, if the data Ripple requested were provided on an aggregate basis, then no personal information of any SEC employee would be provided. So how then could the dissemination of such information constitute an unjustified intrusion into the private financial affairs of any SEC employee? Because that's what the SEC is arguing. This is an unjustified intrusion into the private affairs of SEC employees. Again, just on the aggregate, no names attached, nothing like that, no personal information, but it's still an intrusion. So let me ask you something. It's like the U.S. Census also publicly shares aggregated data of United States citizens. Is the sharing of such data an unjustified intrusion into the affairs of United States citizens? No, of course not. You can look at census data, you don't know who the hell did what, lives where. No, none of it's there. Like, and you just got to kind of wonder, like, when the judge reads this, you just gotta imagine they're going like, what the hell are you talking about, asset? Like, that's what I'm hoping crosses the judge's mind. What are you talking about, you stupid asset? That's what I'm hoping. Because there's no, Ripple's explicitly stated, just on an aggregate basis, and they're acknowledging that here, and they're still saying that that's intrusive. How stupid do they think we all are? Apparently pretty stupid. They're just, I don't know, they don't lawyer God. I mean, come on, dude. All right, on to the next page now. Here we go. Under Section 8, somewhere around here, I'm going to be jumping in where I'm circling if you happen to be looking on your screen. Actually, yeah, right here. Ethics Counsel maintains a prohibited holdings list of entities whose securities SEC employees are categorically barred from holding. This list includes entities regulated directly by the SEC. Such as broker-dealers or national securities exchanges, which are registered with the SEC. This list has never included Bitcoin, Ether, or XRP, which are not alleged to be those types of entities. So pause right there. So that's what I was talking about at the outset of the video. So XRP, Ether, Bitcoin, so not included as a prohibited holding. And they said it's because it's not those types of entities. And so what they're citing is that they're not broker-dealers or national securities exchanges. Well, of course they're not. Nobody's alleging that, right? Nobody would think that. XRP is a decentralized cryptocurrency. That's pretty much it in a nutshell. Anyway, but then they also write, Ethics Counsel also receives a watch list. Now, this is where it gets interesting. Ethics Counsel also receives a watch list for entities that may fall within supplemental ethics rules. For example, an entity may appear on the watch list when relevant to a pre-investigation matter under inquiry, but would appear on the watch list, and an employee may not be permitted to engage in trading in securities related to that entity when it is under investigation. Now listen to this. Bitcoin and Ether never appeared on the watch list, while XRP appeared on the watch list as of April 13th, 2018. So these are two separate lists. You're talking about prohibited holdings, which is the one that I just talked about. Bitcoin, Ether, and XRP, none of those three ever on the prohibited holdings list, meaning that the SEC employees were allowed to buy, sell, hold to their heart's content, right? But this is different. The watch list, this is where they're stating that because of a investigation situation coming up with XRP, now this date, April 13, 2018, employees of the SEC no longer allowed to purchase XRP. And but see here the SEC admits its employees were not barred from buying XRP until April 13th, 2018. And they say this doesn't matter because being on the watch list merely indicates that there is an ethical question surrounding SEC employees buying XRP, not that the Ethics Council is claiming that XRP is a security. However, the SEC itself is claiming XRP is a security. So if employees were buying it up until April 13th, 2018, then clearly it's not obvious to market participants that XRP is a security. And so this is the data that Ripple wants, and it makes all the sense in the world to have it aggregated and sent out. This is very pertinent to the case, and it plays directly into the strength of Ripple's fair notice defense, which is a completely valid defense. So this information deserves to be out there. We'll see what ultimately comes of this, but those are my initial takes having read through this 6-page document right there. I don't see how the SEC can logically get around this. And so you see the monkeying around that they had here, as I highlighted, but it's really difficult for me to believe that this lawyer actually believes what the hell he's writing. It's very difficult for me to believe that. So let me know what you think in the comments section below. But there you go. The SEC never barred their employees from purchasing XRP until April 13th, 2018, and even then, it was because there were ethical concerns since there was an investigation situation at that. Not that they were imminently going to charge Ripple, but just investigation status made known, and so as a result, their employees could no longer do anything with XRP. But even then, you still can have a question. You're like, okay, why the hell would it take you so long to 2018 to determine whether or not you even want to investigate, right? And it's not that it was actually technically it would have been a hair sooner than that, but still, it doesn't matter. Like all those years pass, none of this adds up. It's a bunch of nonsense and hoo-ha, if you ask me. So anyway, I would love to hear what you think about this, but those are my initial impressions upon reading this. I am not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.